The following program is made possible in part by the Dayton Bar Association.
Good evening. My name is Jeff Swillinger, and I'm your host for this evening's You and the Law. This is our first edition for 2021 to 2022. My guest this evening is Debra Lavey, an attorney with Advocates for Basic Legal Equality, also known as ABLE, here in the greater Dayton area. I'll introduce Deb again in a moment and get a little bit more information from her to start, and then we'll get into the meat of the program. I want to give you a little bit of background. The show, as was announced moments ago, is underwritten by the Dayton Bar Association. The phone number for the Dayton Bar Association, should you need to call it, is 937-222-7902. And that's a number of which you can also reach the Bar Association Lawyer Referral Service. There is a direct dial for the Lawyer Referral Service, 937-222-6102, if you're looking for an attorney to help you. And if you call that number, you can ask questions of a member of the staff regarding how the Lawyer Referral Service works, and go from there. If you'd like to call in this evening, this is a live show. It also is live streaming. I'll give you a little bit more information on that in a moment. The number at DATV is 937-223-5311. Those numbers may appear on your screen now that we're Zooming at this point, rather than doing our interview in person. I'm not always sure what's on the screen and what's not. But again, 223-5311, should you like to call into the station. And if you have any questions during normal business hours, you can call the station, or you can go to the station's website, www.datv.org. Now, let me give you a little bit more information about how you can see the show, since this is our first show this evening. As I said, we're live, and if you're watching us on Channel 5 in Dayton, Riverside, Butler Township, Jefferson Township, Brookville, or New Carlisle, or on Channel 6 in Englewood, Vandalia, Union, Clayton, Harrison Township, Huber Heights, Trotwood, Xenia, or on Channel 23 in Clark County, Fairborn, South Charleston, and within the boundaries of Wright-Patterson Air Force Base. That's how you can reach us on television this evening. We are not live in the south suburbs, but the Miami Valley Cable Council has consented to showing our program on tape in the southern suburbs on channel 991, and that will be replayed in accordance with their schedule. So if you're sharing this program with friends, they'd like to watch it on tape through their cable carrier in the southern suburbs of Dayton, you can tell them it's channel 991, and they can contact the Miami Valley Cable Council, and they will give you an idea of when the show will be viewed. Now, I have some times that the show will be available. I believe this is on DATV, Dayton Access Television. That is our sponsor this evening, along with the Bar Association. And the good people who make this possible are our staff and volunteers at DATV. I believe, in addition to seeing the show live tonight, with the first Friday at 11 a.m. and the second Monday at 11 a.m. After tonight's show, and then the second Wednesday at 9 a.m., the fourth Saturday at 5 p.m., and the first Monday at 11 a.m. Now that's a lot of information to absorb. So I would just tell you, if you want to call a DATV, they'll be happy to give you information about the show. And if you'd like to go online, once again, www.datv.org. Okay, let me see if there's anything else in the way of housekeeping for tonight before we get started with our guest. No, I think that's all. Oh, I will point out one other thing. Normally when we're doing our interviews with our guests in person at the station, I can take a call and hear your question at the station live, and we can respond to you. Now that we're Zooming, the question will come into the station, and the good folks at the station will send me a summary of your question. Deb, I will read it. I will pass that along to our guest, and in this case, Deb Lavey, and we'll do our best to get your questions answered. And if we can't answer your question, maybe it'd be the kind of question we could tell you who can, and we can make you aware of that. So let's get started. Again, my guest is Debra Lavey, a dear friend, a wonderful lawyer. This is my fourth year doing the show. Our former host, Michael Monta, did the show for over 26 years, 27 years. I hope Mike is watching this evening. We have a variety of different types of guests, lawyers and non-lawyers, law professors, and so forth. But Deb has been good to start off the show, each of our 4 seasons, talking about the whole eviction situation, the eviction crisis, I choose to call it, particularly over the last few years, and the impact of COVID and other issues on evictions in the greater Dayton area. But of course, there's federal law and state law issues surrounding all of the matters involving evictions. And we'll get into that now at this point. Deb, if you could just tell us just briefly a little bit about your work and what you do. Maybe we can get into a little background of the eviction process if you choose to take us that way. And I know that you've put together a nice list of issues for us to discuss, and I'll just turn the program over to you, and I'll probably have some questions along the way. So with that, Debra Lavey, attorney with Advocates for Basic Legal Equality. Welcome, Deb.
Thanks, Jeff. It's good to be with you this evening. And I work for Advocates for Basic Legal Equality. We're a nonprofit law firm. We provide free legal services to low-income individuals and groups in civil matters. If you're in need of legal assistance, you're welcome to apply for our services. There's a couple ways you can do that. One, you can apply through our phone line, and that number is 1-888-534-1432. And you can do that Monday through Friday. Or the other way is to apply online, and we do have a website that you can apply through, and that's www.legalaidline.org. So it's good to be here with you tonight to talk about evictions.
Okay. And again, evictions and really the larger issues that have come forth surrounding the whole eviction process. And I will say to our viewers, our listeners, although Deb represents exclusively tenants in these matters, we've discussed these issues a number of times, and while Deb is an advocate on behalf of her clients or tenants, uh, we both understand that we want to try and present a balanced view, if we can, of the issues. Bit of advocacy, I'm sure, on certain points, but we want you to understand what the laws are, what the procedures are, and the process is, so that those of you who are listening, whether you be a tenant or a landlord or just a member of the general public, you'll get a good and fair overview of the situation. Is that fair, Deb?
Yes, that's great, Jeff.
Okay. So you've been kind enough to, in past shows, talk about the eviction process a bit. We started off 4 years ago with a lot of nuts and bolts about the process, and we've kind of evolved into the crisis that has developed nationwide over the last couple of years, in particular, adding to any long-standing issues that might have been there for landlords and tenants. So why don't I turn this over to you and kind of let you start where you'd like to in terms of giving us some background on what you do, how you assist individuals, and how that folds into the larger issues we're talking about tonight. Okay?
That sounds great. So this is my 22nd year with legal services. For the past 17 years, I have been representing tenants in a variety of housing related matters. As we've already discussed, I represent tenants in eviction cases, trying to preserve their housing and preventing homelessness. We also at Legal Aid represent tenants who have Section 8 housing choice vouchers, and we represent them to preserve their voucher through the Public Housing Authority. We also represent tenants from time to time in discrimination cases. We also work with tenants that want to form tenant groups and help them advocate for their rights in the complex that they reside in. And then we do a lot of community education, working out in the community, educating tenants and landlords. And lastly, since the pandemic hit, I've been spending a lot of time collaborating with other groups and also advocating for changes in the law to protect tenants.
Okay. And we'll get into maybe mentioning some of those collaborating partners when you talk about some of the issues that I know we're going to get into pretty quickly here. So with that in mind, okay, you've given us some of your background, some of what you do in your daily life. Where do we go from there?
Yeah, so I mean, I think one thing that's really important to mention is that prior to the pandemic, we were seeing an eviction crisis here in the city of Dayton. Matthew Desmond, a sociologist and an author, wrote a book a number of years ago called Evicted. And that book became part of the national conversation. And in his book, he indicated that every year in this country, people are evicted from their homes, not by the tens of thousands or even the hundreds of thousands, but by the millions. So we were seeing lots of people being evicted pre-pandemic. Many tenants were living on the edge at that time, and for many, the pandemic has pushed many of them over the edge. So I know I was on the show last year, and we talked about some of the changes in the law since the pandemic hit. So I thought it might be helpful to recap that and talk about where we are, what protections are in place for evictions, and what are not in place.
I think that's great. And, you know, feel free to talk about the secondary, the primary, the secondary, the tertiary issues of how evictions can impact upon families and individuals in terms of their work, their home life, food, resources, their ability to get their folks that get their children to school, they have a steady address, and the impact of not having a steady address on all of these types of things, particularly for a lot of folks that you represent. Okay, with the understanding, and I always feel obliged to say this, that I understand that people who own rental properties are in business, and that provides a business income, and they have a right to their livelihood. And so in this whole process, what we're looking for is balance, I guess, that protect the rights of both the tenant and the landlord. But please go ahead.
Yeah, I think it would be helpful just to briefly recap the eviction process, and then we could move into the current state of evictions, both in Ohio and nationally. Okay. So in Ohio, evictions are summary in nature, and all that means is that they move quicker through the court system than a typical civil case. And just a really brief overview, if a tenant gets behind in her rent, her landlord can serve her with a notice. Typically in market rate housing, which is housing where the tenant is paying their own rent with no assistance, no subsidy through the government or some other form. If the tenant gets behind in her rent, the landlord can give her a 3-day notice asking her to leave the premises. After those 3 days, the landlord can then file an eviction action. Ohio uses sort of a fancy term for it. It's called a complaint enforceable entry and detainer. Depending on what court your case is being heard in, typically a tenant will appear before the court somewhere between 2 and 3 weeks after they've been served with their complaint. The court that the tenant appears in is dependent on where the rental property is located. So in Montgomery County, there are 8 different courts that hear evictions. If the tenant is evicted at the hearing, meaning that the landlord wins the case, the court grants judgment to the landlord. It's called an entry of restitution here in Ohio. And then the landlord can file something asking that the tenant be removed from the property, that forcible removal that I referred to in the name of the complaint. Typically, that move out will occur anywhere from a couple days after the eviction judgment up to 10 days. And Jeff, earlier you talked about evictions and sort of the after effect of them. And I think it's really important to know that the harms of eviction do run deep. Having an eviction on someone's record can often result in blacklisting. And that means that many landlords will not even consider a tenant as an applicant with a prior eviction filing, not even a judgment, but a filing, even if they won the case. Eviction records often follow people for years, and it stigmatizing already vulnerable groups and blocking them from housing opportunities. It's good to know that in the state of Ohio, there is a bill pending before the Ohio legislature, Senate Bill 158, that would provide for an expungement of an eviction. Currently, there is no state law providing for that mechanism.
Now, over the last year or so in talking with folks, I've heard people say that, or provide details of this process of checking into the background of tenants and choosing not to rent to somebody because they've had an eviction before. Could you give maybe an example of that where someone comes in, they'd like to rent from a landlord, and the landlord, might they ask them or have them sign to say it's okay that they can check into their background, or do they even have to do that? Can they just go out and check? Is it been found to be lawful? What can they do? And then how far can a landlord go in saying, I don't want to rent to you? Can you just describe that process with a little bit more detail? Because I think it may be surprising to some people how that process works.
So how I understand it is many landlords will have tenants pay an application fee and sign a document that gives them authority to run usually a credit check and a background check. And these checks allow landlords to look into the tenant's rental history, their criminal history, their credit history. Uh, but even separate and apart from these checks, a lot of information is available for free online through court systems or other systems, probably some informal systems that landlords share about tenants' rental history. And as I mentioned previously, many landlords are reluctant to rent to tenants, even if an eviction action has been filed, not because an eviction has been granted, but just merely because one has been filed.
I see. And so that can form the basis for a landlord to legally refuse to rent to someone. Is that correct?
Correct. Yes, that
Okay.
often does form the basis for a landlord refusing to rent to a tenant.
Okay. Okay. So, and when that happens, then you get into the issue of, well, one landlord has done that, someone is trying to find a place, another landlord may be able to do the same thing, and then it becomes more and more difficult for an individual to find. And usually, I assume though that the landlords are looking to find out if the tenant is had an eviction, what the basis was for the eviction, non-payment of rent, for instance. Um, and does it happen that one prior bad situation for the tenant excludes them for all time at present, or is it a question of degree sometimes as to how many evictions they might have had or who the landlord is? Is it somewhat case by case in that regard?
I would say that it just depends on the landlord and what policy they have regarding evictions.
Mm-hmm.
Um, the more formal landlords generally have like a tenant selection policy where they list out, you know, how far back they look for evictions, and they may only prohibit based on evictions for certain reasons. Or many landlords just have informal policies that they use in determining who they're going to rent to.
And I guess that usually if there's any direct discussion, and I don't know how much of this in today's day and age is over the telephone, over, you know, smartphones, how much of it's over the computer and emails. Uh, but usually the tenant is dealing with someone who works for the landlord, their agent, their rental agent, that type of person. Is that correct? They're not really talking unless it's a smaller landlord who he or she may own a two-unit building, 4-unit building. But if it's a larger multi-unit type situation, chances are they're not talking to the landlord, right?
You're correct that oftentimes the owner will hire a management company, their agent, to manage the property, and the tenant will often be dealing with someone from that management company, not the owner themselves. It's important to note in Ohio that a management company can be considered a landlord under the Ohio statute, but they would have to have a lawyer represent them in any eviction case.
Okay. Is this a good time to talk about the representation issue and what people say and what rights they have and what rights they don't have, distinguishing the tenancy situation, landlord-tenant situation from criminal cases, for instance, where people may have actually constitutional rights that are protected, and in many cases where, or all cases where individuals may ultimately be incarcerated if convicted of a crime. They may have a right to counsel and appointed counsel in many situations. That's a lot different here with some very limited exceptions, I understand from you. Why don't you talk about that a little?
Yeah, so I already quoted Desmond once, so I'm going to quote him again. In his book Evicted, he said that 90% of landlords have representation and 90% of tenants don't. I would actually say that figure is a little low. I would say landlords have representation high of 90 and tenants would have representation much lower of 10%. So as you mentioned, Jeff, in the criminal arena, low income individuals have a right to an attorney to represent them in their criminal case, right? So typically the public defender's office is the office that provides that representation. In eviction cases, tenants generally don't have a right to have a lawyer represent them. And so there has been a movement across the country. It's called a right to counsel movement to provide lawyers for low income individuals in eviction cases. And in fact, in Ohio, there's 2 cities that have right to counsel right now. First, Cleveland passed that a few years ago, and they provide a right for a low income tenant to have counsel in their eviction case. And then the city of Toledo just passed right to counsel 2 weeks ago, and they will be providing attorneys to represent low-income tenants in their eviction cases.
Now, just let me ask you a quick question. This is kind of a red herring maybe, but I understand that some evictions within a city can be filed either within the city municipal court or within the county court, even though the property's within the city where that, or the city is within the county where that filing may be made with the county. What controls in Cleveland or Toledo? Is it a question of whether it's filed in the municipal court or the county court as to whether they get counsel? Let's suppose someone says, okay, Toledo's filing, Toledo has a right to counsel to the limited extent that you discussed that, and Cleveland, but someone says, well, I'm just going to file my eviction in the county, in Cuyahoga County, or I'm not sure what Toledo's county is, and try to get around having to do that. Does that happen?
So Toledo's county is Lucas County, just for a fun fact, in case you wanted to know that. So generally, a city ordinance would apply to where the rental property is located. So if the rental property is located within the confines of the city, the right to counsel would apply for those tenants that rent within the city's jurisdiction. But you're correct. In city of Dayton, for example, if a tenant is renting, in the city of Dayton, a landlord could either file the eviction case within Dayton Municipal Court or Montgomery County Common Pleas Court. But any city ordinance that would protect that tenant would apply in either court, so long as the property is within the city limits.
I see. Okay. Well, please go on. I took you a little off your course there, but the idea of representation, I think, is paramount in tenants' minds when they're in a situation where they might be evicted. So we try to address that up front. I'm seeing that there's someone says we have 3 people on the chat here, but I don't see any question. Maybe one is coming in, so I may interrupt you if I see in my chat column that a call's coming in. Please go ahead, though.
Yes, I think now, since we have an understanding of what has happened or what the eviction process is, it'd be good to talk about what we've seen happen throughout the pandemic. In March of 2020, former President Trump signed the CARES Act, the Coronavirus Aid and Relief or Rescue Act. I'm not sure if I got that all right. And as part of that, there was a 120-day eviction moratorium. That moratorium only applied to tenants who resided in either subsidized housing or public housing, which is housing owned and operated by the Public Housing Authority. A moratorium is sort of a stoppage on eviction filings. That moratorium ended in the summer of 2020. And then in the fall of 2020, September 4th to be exact, the CDC issued a nationwide eviction moratorium for all housing. So the CARES,
Center
oh,
for
go ahead.
Disease Control.
Yes, and prevention, correct.
Okay.
And the distinction between the CDC eviction moratorium and the CARES Act moratorium is this. The CDC moratorium applied to any rental housing throughout the country, where the CARES Act eviction moratorium only applied to those tenants who resided in subsidized and public housing. So that moratorium was issued on September 4th. As I mentioned, it was a nationwide moratorium. In order for tenants to avail themselves of protection under the moratorium, they had to complete a form called a declaration. They had to serve it on their landlord. And then sometimes they had to file it in the court case if there was an eviction filing and asked to be protected. This eviction moratorium was set to expire at the end of December 2020. Congress extended the moratorium, I believe, around December 27th of 2020 and extended it until the end of January 2021. Many thought that they did that to give the Biden administration an opportunity to decide how they wanted to move forward. President Biden became our president in 2021, and then the CDC then proceeded to extend the moratorium several more times after that. And it ultimately expired at the end of July 2021. Several days after the expiration, the CDC issued a new moratorium. This moratorium was slightly different because it only applied to parts of the country that were seeing significant spread of COVID. Unfortunately, about 3 weeks after the CDC issued this new moratorium, the US Supreme Court struck it down and found it unconstitutional. So currently we have no eviction moratorium, no national eviction moratorium.
Okay, so no national stoppage of the filing of evictions based upon current situations in this country that gave rise to the original legislation or the CDC's regulation. Okay. Okay.
Yeah, that's correct.
Okay.
And it's important to note that many states, since the beginning of the pandemic, had their own moratorium that they issued to provide protections for tenants to prevent evictions. Ohio was not one of them. So Ohio was one of 7 states that provided no statewide protection for tenants. So Ohio, Wyoming, South Dakota, Oklahoma, Missouri, Georgia, Arkansas, and Arizona were the 7 states that didn't provide any protection for tenants during the pandemic. And what I mean by that is that there was no order from throughout the state stopping evictions. I mentioned the CARES Act eviction moratorium. I mentioned the CDC eviction moratorium. Those were national moratoriums. They were not statewide moratoriums. We did see at the beginning of the pandemic, back in March and April and May of 2020, individual courts stopping hearing eviction cases. So there were sort of different things that happened. Some stopped hearing eviction cases, some stopped move outs, some stopped filings. But it wasn't a statewide order. It was court by court, and for both landlord and tenant, you didn't really know unless you reached out to that court.
I see. Let me ask you, so at this point, we are in a position where the filing of the eviction is permitted nationwide. Let's talk, if this is timely, if you want to talk about this later, you just say so, but let's talk about the difference between a moratorium on the filing of the eviction and the tenant's obligations under their lease, and particularly to pay rent. Okay, because I think people may have had, and maybe newer tenants who are not as used to the system may not understand that just because there was a moratorium on the filing, which, as you've described, most instances is no longer in place, that doesn't necessarily mean that the rent that they had to pay was stopped, or that even if there was a stoppage, that they had no future obligation to pay it. You want to talk about that a little bit?
Yeah, and let me just clarify a couple of things or a few things about the moratorium. So even when the CDC moratorium was in place, landlords could still file eviction. Landlords could still serve eviction notices. They could still file eviction complaints, and in many cases, they were still having eviction hearings. What was typically happening in Ohio is if a tenant had served this declaration and the court found that they met all of the elements of the declaration, they would either stay the case, so they wouldn't grant the eviction, and they would continue the case until after the moratorium expired, or in some courts, they would grant the eviction, but they wouldn't move the tenant out while the moratorium was in place. Under the moratorium, though, in order for the tenant to get protection, I mentioned that they had to complete this declaration. And one of the elements of the declaration is that they had to swear that they had applied for rental assistance. So the moratorium, all of these moratoriums I've talked about were not a rent forgiveness program. So the moratorium did not take away the rent arrearage. It just suspended the ability of the landlord to put the person out of their home. So it's really important that we've had 3 infusions, or we've had 3 rental assistance bills that have passed since the beginning of the pandemic. And the goal of that money is twofold. 1, to keep tenants housed, but 2, also to pay landlords so that they can pay their bills and keep their businesses up and running. So we had the CARES Act that I mentioned that passed in March of 2020. That was the first infusion of rental assistance that we saw. The second was at the same time Congress extended the CDC eviction moratorium. I think it was December 27th. They signed what we now call as ERA 1. And that, I wanted to look at my notes to get the right amount. That was through the Consolidated Appropriations Act, and it set aside $25 billion for emergency rental assistance. Right now in Montgomery County, we have two infusions of that money. We have one through the Miami Valley Community Action Partnership. They were the same agency that administered the CARES dollars in 2020. And then we have Montgomery County that is contracting with 4 groups: Homeful, Salvation Army, Goodwill, and Catholic Social Services. And they're also administering these funds. I just want to put a plug in that if you're a tenant that needs rental assistance, you can apply at either of these places. For Miami Valley Community Action Partnership, you can apply at mvcap.com, or if through the county, you can call the 211 number and they will connect you with the right organization.
And again, those organizations are, feel free to repeat that. And if you have their phone numbers directly, you can say that also.
Yeah, so for CAP, the best way to apply is online. They have an online portal. So that's www.mvcap.com. And I think they have like COVID relief button that you push and can fill out all that information. And then for the county, you can either do 211 or HelpLink, and they'll connect you to the right organization. And then the third round of rental assistance is known as ERA2, and this is from the American Rescue Plan Act, signed by President Biden on March 11th, 2021, and that set aside $21.5 billion. And I just want to mention that the ERA1 money, that second round of rental assistance, communities have until September of 2022 to spend that money, so one more year. And then the third round of rental assistance, that ERA2, communities have until September of 2024 to spend that money.
Now, we only have, I'm going to guess, about 15 minutes at most left. But you think it's important that we say how that money would be used specifically, because people have arrearages on rent, that money that was abated but didn't go away, that obligation to pay it ultimately, and then they have new rental obligations ongoing. So are there restrictions on these monies if they're distributed to a tenant, and a tenant is eligible, goes through the process and is eligible? How is that money going to be used to offset monies that they haven't paid to the landlord? Is that a fair question?
Yeah, that's a great question. So I'll tell you what my understanding is. Obviously,
Okay.
the organizations that are administering it could probably get to the more specifics, but generally speaking, the organizations will assist with 12 months of back rent and 3 months of future rent. So typically 15 months of assistance. However, it's my understanding that if they're able to assist under both ERA1 and ERA2, it could be up to 18 months of rental assistance for a tenant. Generally, how the process works is the tenant has to be determined eligible for this rental assistance. The agencies that I talked about will do that. They'll engage in that process and determine whether or not the tenant's eligible. And then the landlord has to complete a landlord statement indicating, what's owed. So generally they'll pay the rent, they'll pay reasonable late fees. And so I should mention that the city of Dayton passed a late fee ordinance in June of 2020, capping late fees at 5% of the monthly rent. They typically will pay court costs if the case is an eviction, and they will also pay attorney's fees.
Okay, now, because of our time, and I think we've gone through your list well, but there's still some other points to be shared. I'm concerned, just from a tenant's point of view here, as well as the landlord's really, because what is the landlord obligated to accept, and what is being accepted? What are some of the nuances that occur when the tenant thinks, well, Miami Valley Community Action Partnership is willing to pay this amount of money. They have these funds to help us. It's not their money, but they're distributing that money, obviously. But the landlord says no. Or the landlord says, no, it's not just about non-payment of rent. It's how you treated the property, or you were always late paying your rent even before. And is there an obligation that when the landlord completes a response that they have bought in to what the process provides for in terms of rental assistance? Can they back out of that? Do landlords do that on a regular basis because they just want the tenant out? What kinds of things? Because that's where the devil's in the details sometimes. It seems to me that the tenants go in thinking, well, I've got money. Why won't they accept it? Is that fair?
Yeah, so you're asking some really excellent questions that get to, as I say, when the rubber meets the road, right? How does this really work, and what are the challenges? So I'll try to address them one by one.
Yeah, let's spend time with that, because if there is a multitude of information that we haven't covered, we'll discuss how we do that, maybe another show or whatever. But let's get to, I think these are hardcore issues, as you said. So
Yeah, so the first thing I would say is that if you're a tenant and you live in the city of Dayton, pay to stay was passed, and pay to stay, a local ordinance passed this year, and pay to stay provides that if a tenant can pay their back rent and their late fees at the notice stage, and they offer it even though it's late, the landlord has a duty to accept it under pay to stay. If they're at the court stage, they have to offer the rent, the late fees, and the court costs by the time of the hearing. So if you have a landlord that doesn't want to take it, pay to stay could be a defense for you if you have all of that money. And that money could be through a rental assistance agency.
mm-hmm.
If you're not in the city of Dayton or Yellow Springs that has pay to stay, sort of where we're the area we're talking about, pay to stay exists in several other cities throughout the state of Ohio, but I think we're mainly talking to people that live in a certain geographic area. The other thing to keep in mind is that if your landlord has had a pattern and practice of accepting your rent late, so typically 3 or more times, and you're offering it late again, that could be a defense to the eviction. That being said, those are difficult arguments to make without a lawyer. So it gets back to what we talked about before, how important it is for tenants to have representation. So there might be a defense to prevent the eviction. And then the third piece I would mention is both the ERA 1 and ERA 2 funds allow for a rental assistance agency to pay the rent and late fees and all of that directly to the tenant if the landlord refuses it. So the agency could pay it to the tenant, who could then, tender it at court or, find other ways to be able to preserve their tenancy. So that's another option as well.
Are they allowed to use that? You said other ways. Now I want to just ask, can they use that if they can't get the services of the legal services of organizations like Legal Aid of Western Ohio, or Advocates for Basic Legal Equality? Can they use that money to hire a private attorney?
I'm not sure about that. That's a great question, Jeff. I think that once the money is released to the tenant, they can use it for things, reasonably related to their housing. So I think there would be an argument to make that they could. Now, an important piece to keep in mind is they still owe the rent to the landlord. Right. So if they would use some of that money to hire a lawyer, they would likely be short on what they owe the landlord for rent.
Right. And if they use it for other things, not only are they not going to be able to pay for the rent, but I suspect if they end up back in court, the court's going to ask where the money went, and it went for something that may, to the tenant, have been very important. And it may very well be that it was important. It didn't comply with the law, and that could be a basis upon which they wouldn't get much sympathy from the judge who was hearing the matter, even though they might say, I understand that you had to pay school fees or this type of thing, but that money was explained to you when you got it for your rent. Those are again, rubber meets the road, tough situations, I'm sure.
Yeah, and I just wanted to maybe interject just really quickly as we talk about non-payment. One thing that's really important to keep in mind is the issue of cost burden. So typically tenants shouldn't be paying more than 30% of their income on rent and utilities. A Harvard study from 2020 found that 5 out of 10 Black and Hispanic renter households are severely cost burdened, spending more than 50% of their income on their housing. And if you've been at the great new Metro Library in downtown Dayton, they had a wonderful exhibit on redlining. It just left, I think September 25th was the last day. I think it's now at University of Dayton. But if you go through that exhibit, you'll see, that due to decades of inequality in our housing system, communities of color and low income women often feel the impacts of eviction most, right? Because if you look at the redlining exhibit, you'll see the discrimination that existed in the city of Dayton that we still are dealing with all these decades later. So I just want to say that, Black women are more than twice as likely to have evictions filed against them as white people, and that less than half of Black and Latinx families own their homes compared to 73% of white families. Black and Latinx tenants are also twice as likely as white tenants to report that they have no ability to make rent each month. And this is based on long-standing systemic income and wealth inequality that have put communities of color and women at higher risk of eviction. So I just want to make sure that we're framing it in the right way, and we continue to see those challenges in the city of Dayton and in Montgomery County.
Yeah, well, and in the surrounding counties as well, and the areas that our program reaches, going over into Clark County and so forth. I know that you intended to say that also. We are in a situation where I'm going to be advised any minute now. I think I have 4 minutes remaining. Because we're on Zoom, and Zoom is still relatively new in terms of our delivering our program on Zoom, I'm seeing these numbers grow under my chat column here on my screen, and I'm afraid that even though I'm not seeing any questions, that others may be calling in and asking questions. I hope I could get some designation here from the station as to whether there have been callers and whether somehow I'm missing those. If I have, I apologize to the callers if they're still watching us and listening to us, that we haven't been able to do this. And if it's my responsibility here, I apologize. And if it's others, it's probably still my responsibility because I should have known how to work this through. If you want and you have questions that haven't been answered, if you want to call the station tomorrow, and I'm not sure, I don't have anyone's authority on this, but call the station and tell them that you had a question you couldn't get through. I'll ask my contacts there to get those questions to me, and I'll get those to you if that's okay. And if you want to leave a phone number, caller, I'm talking to the caller now. If you want to leave a phone number, then maybe I can ask Deb again if she would return those calls, if I get those to her. She's always been gracious to do that in the past, so that no one is disappointed that they didn't get their call answered. Now, I think Deb's last point was a very, very fundamental and important point, and a very global point affecting the larger population. And I don't want to be dismissive. I think we could probably do a program on redlining, its history, whether it continues today and so forth. I guess that's something we can talk about, Deb. But it's important to see from all sides how the community is affected here, without question, in these situations, and which groups of people are affected even more than others. And again, I want to be fair to the landlords. I know past shows we've had an attorney who works primarily with landlords and with rental agents and so forth. When we were talking about more of the basics a couple of years, maybe 3 years ago. And I want to make it clear that we understand that landlords have a right to own property, and they have a right to rent that property. And under the Ohio laws that we're talking about here, they have certain obligations. They understand that, and they have certain rights. and the tenants have certain obligations and certain rights also. And because you are representing tenants and because of so many of the impacts that the laws have on the tenants and the secondary and tertiary impacts I'm talking about, I've chosen to have you come on the show and talk about this. But it's so important that each side plays its part here and meets its obligations, and hopefully there's less chance for problems. But that having been said, um, maybe you could give some idea of how many new eviction cases come into your offices this week or each week, just approximately, or each month, and how many attorneys you have to service those multitude of cases. I don't know if you want to talk about that.
Yeah, I don't know that I could give specific numbers, but I can just say that the need for representation far exceeds our ability to provide it.
Okay.
There's a significant need for tenant representation in eviction cases.
Yes. Okay. And that was clear throughout your presentation here. Well, I'm expecting to get a notation here that we've met our time, but thus far I haven't received one. Is there any last point or two, to the extent we have time? I may have to interrupt you, but that you want to make relative to this your topic for tonight? Time to wrap up, they just told me. Okay. Anything else you want to add tonight?
Well, I just wanted to say thank you for asking me to be on the show, and I'm always happy to talk about landlord tenant issues and engage in this dialogue and hopefully educate both landlords and tenants about what's happening in our community. So thanks for having me.
Well, it's a real pleasure. Thank you for continuing to kick off each of our seasons on these topics. We appreciate it very much, and thank you. And to the viewers, the listeners, thank you. And if they will have questions, feel free to let the station know if you have questions that haven't been answered. They'll get those to me, and I'll do my best to get you answers to your questions on such an important topic as that we've discussed this evening. With that, Deb, thank you, and until we talk again, good night.